We're going to talk tonight about some recent changes to the Michigan Lien Law as it applies to design professionals specifically. There have been some changes that were signed into law by Governor Snyder about the middle part of December of last year, and actually we're a little bit surprised at how quickly those bills moved. Usually the legislative process is something of a bloodbath, and in this case, not only were we able to move the bills very quickly, but did so with virtual unanimous support. In fact, it was unanimous in the Senate and only 5 votes short of that in the House. And that led to something we didn't expect would happen, and that's what's called an immediate effect vote. Typically, changes to the law become effective 90 days after a legislative session ends. In this case, because of the immediate effect vote, the law that we're going to talk about tonight has been the law since the middle of December. And that's a little bit, it's a little surprising, but it's also consequential because it adds some additional requirements that you really have to be aware of when you claim a lien. And claiming a lien in sort of big picture, we like to talk about what's called the American rule, lawyers do, and what that really means is everybody pays their own lawyer. That's unique to North America, unless there is a statute that changes that rule. The lien statute includes a provision that changes that rule. So the reason that this was a little surprising and perhaps a little dangerous for a design professional is if you had claimed a lien and tried to prosecute a lien anytime after the law became effective and you didn't comply with the law, you would be exposed to that argument, that in fact you had committed an act which would expose you to attorney's fees. So that was entirely unexpected. At this point, it would be the law anyway, because we're now well past the 90-day period. So a couple of things. First, I put this in here for my insurance carrier. They just say, you know, when you do things, you really don't want people spreading it around. Don't worry too much about that. There's an email address at the end, and if you'd like a copy of the slides, please don't distribute them or present them, but if you want them for reference, send me an email at that email address, and I'll send it to you. This is a little more important. I do continuing ed occasionally, and I see people writing notes, and that's great, wonderful. That tells me that I'm saying something that you find valuable instead of just talking. And that's certainly satisfying. However, what I don't want you to do is 2 weeks or 3 weeks or a month or 6 months from now say, you know, back on, what is today, April 18th, I attended a seminar and the speaker said do this and I did it and I didn't get the result I wanted. This is not legal advice. It may sound like it, but you can't rely on it. This is the first thing they teach you in law school right here. It should be the first thing they teach you as an architectural student. They don't, but they should. And that is always consult an attorney. I'm going to say even if you had a good day and you don't need to, consult the attorney qualified in the area of law pertaining to your specific legal issue. So that's very important. If you have a lien issue, talk to a lawyer. Don't write down what I said tonight and try to act on it. One other thing, continuing education, Michigan Occupational Code. I believe this is true for engineers as well. Requires architects to complete 24 hours of continuing ed for every 2-year cycle. And there is in the back here a sheet. Write your name on the sheet and put your email, write your email address, and I will tell you what I tell my students. Write your email address so we can read it. And if you do, we will send you a certificate. You'll get a certificate that, if you're ever audited, will be adequate for that purpose. And I believe it can also be used for other states, as long as you have the certificate. Under the board rules, universities are authorized to offer qualified CE programs, and LTU is specifically mentioned, so you will get 2 hours of credit for that, if you write your email address in a fashion that we can read. Now, before we start to talk about how we change the lien law, we're going to talk a little bit about what the lien law is and what a lien is. And I find that many architects, I use the term architects, I should use the term design professional. I get that. It is broader, and please understand they are interchangeable as I use them. If I say architect, it means design professional. If I say engineer, it means design professional. For purposes of what we're discussing now, they are interchangeable. And if we look at what the history of the lien law is, why do we have it? Where does it come from? The idea of a lien dates all the way back to Jefferson. Lots of stuff dates back to Jefferson. He was a pretty smart guy. The reason behind it, at the time, Washington, D.C. was a swamp. And some say it still is, but back then it certainly was, literally. And the thinking was, we really need to build an environment, create a city that's befitting of the capital of the United States. And there was no development. There really wasn't anything. So the idea was, or the belief was, that creating some mechanism where people who did the construction work or added value could get paid would spur that development. And really it's borrowed from the French. The French did it much earlier than we ever did. It goes way back to the 1600s. Now, I don't know if anybody claimed a lien for Notre Dame, but somebody might in the future, I suppose. There's a little construction work that has to be done there. Anyway, the idea is not new. The idea as we practice it is newer, but it's certainly not new in the sense that, it does not have a history. It has a very long history. The more recent history of the lien law comes from auto mechanics, and you'll hear the term mechanics lien. That's not really accurate. A mechanics lien is not a mechanics lien. A mechanics lien is not the sort of lien a mechanic would assert. But obviously first came the automobile, and after the first automobiles, they broke down, so we had to fix them. So now we have auto mechanics. So everything's great except when the mechanic doesn't get paid. And it created a bit of an issue for the mechanic, because I've worked on this vehicle, I have improved the value. Obviously, a vehicle that operates, that's drivable and functions, is more valuable than one that isn't. So I've added value to this vehicle. Unfortunately, the way the law was structured, I didn't have any claim to the vehicle. I had a claim perhaps to repairs, but they're now subsumed within the vehicle. And I couldn't, if I retained the vehicle and refused to give it back to the owner until I was paid, the law would say I have converted it. And that's a fancy term for the civil version of theft. If the car owner comes back and says, I want the vehicle and I'm not paying you for the repairs, the mechanic was required to hand it back over because the mechanic had no claim to the vehicle. Literally, what the mechanic had was a breach of contract claim. You can sue the owner for breaching the contract, but you cannot keep the vehicle. You have no claim to that vehicle, and if you do, you have converted it. So, in kind of a perverse way, The mechanic has repaired the vehicle, retains the vehicle because he or she isn't paid for the service, and winds up on the receiving end of a civil lawsuit for having done so. And that was kind of a problem because, in theory, the damage is the entire value of the automobile, whereas the repairs are some small fraction of the automobile. So I'm exposed to a much bigger claim than I could assert. To allow the mechanic the right to retain the vehicle, this idea of the lien was applied here. Now, I say the mechanic's lien is not really the proper term. It isn't the proper term. What a mechanic asserts is an artisan's lien. There's some fine legal differences which really aren't that important for what we're going to talk about here. In the odd sense, the lien that a design professional would assert is a mechanic's lien. I can't explain why that is, but that label does apply in the construction and the design setting. And if we look at the lien laws today, they are available to design professionals in most states, not in every state, most states. In many states, the design professionals' rights are the same as they are for construction contractors. Some states, they're a little different. Michigan is now one of the states where they're a little bit different. And if we look at how the law develops, it's incremental. It does not develop in large steps. It's very small steps. And it usually lags what's happening by a fair period of time. And as the lien law developed, the question became, does it apply to a design professional? And the answer was, well, we don't know if it does or not. And ultimately, rather than creating a law that did, which probably would have been the right approach, we simply grafted design professionals onto the law that already existed for construction contractors. So that's how we get to a situation where the requirements for construction contractors and design professionals are the same. It just made sense at the time. We're just going to add them in to a structure that's already in place. As I said, a handful of states don't allow design professionals to claim liens at all. There are no states that don't allow construction contractors to claim liens. You can claim a lien as a construction contractor in any state. Off the top of my head, yesterday when I did this in Lansing, I could only name two. I can now name three. Alaska, Kentucky, and Ohio are three states where design professionals simply do not have lien rights at all. I don't know why that's the case in Alaska. I don't know why that's the case in Kentucky. I'd suggest maybe that it's the case in Ohio because they're a little backwards in Ohio. And be that as it may. So certainly isn't a big issue. It's just something to be aware of if you do practice in other states, which does seem to be a growing sort of a thing. Now, if we look at the Michigan Lien Law, the concept in Michigan goes back quite a ways as well over 100 years. But what tends to happen over time is we make these incremental changes to the law, and we get to the point where a particular statute is kind of this cobbled together mess of all of this stuff. And when that happens, we step back and generally will rewrite it to really reorganize it and put it back in some sort of usable form. That happened in Michigan in 1980. So if you were to look at the lien law in Michigan today, it would date to 1980, the current law, even though the law has been there much, much, much longer. The lien law, the 1980 version of the lien law, did not apply to design professionals. There was no reference in the law to an architect or an engineer. It was extended to architects and engineers by judicial decision, which you have courts interpreting the law. Well, courts interpreted the 1980 law to suggest or to provide that, yes, in fact, it does cover design professionals, even though it didn't say that. And the statute itself was eventually changed. So now it does actually mention architects and engineers. So we are certainly covered within the context of the lien statute. No question is a long way of saying there's no question that an architect or an engineer has lien rights in Michigan. So really, what is a lien? We talk about having lien rights, but we have to understand what the lien really is in and of itself. And what it is tied to the idea of a mechanic who's repairing the vehicle. There's an added value. So in order to secure the payment, as we've said, the law recognized the lien, which permitted the mechanic to retain the vehicle. But what they're really doing is claiming an ownership interest in the vehicle. I have improved the vehicle. Therefore, the vehicle has greater value before the time when I improved it. I have the right to claim some of that value. I created it, it's mine. And that same sort of thinking applies to design professionals. First to construction and then to design professionals. So the claim of lien is actually a claim in the ownership. That's literally what it is. And that's why a claim of lien has to be recorded in a chain of title, because that's how we keep track of who owns real estate. So in order to be effective, we have to record that claim in the chain of title. And now here comes the rub. I spent an awful long time in school, and I had a corporations professor who summed about 25 years up with 3 words. And he said, follow the money. And he says, if you understand who's paying who and why they're paying them, you'll understand about 97% of what's going on. And the other 3% you don't even need to know. So that basically covers it. And that became the rub for design professionals. That's why we have a problem. It's why we had a problem that we addressed with this statute change last year. That works fine for a mechanic. It even works fine in the construction setting, because somebody has done some work that arguably improved the value of the property. The problem becomes this notion of design, which is sort of illusory when it comes to improving value of real estate. Now, I certainly believe it has that effect. I'm sure you all believe it has that effect, but courts weren't convinced that it had that effect. And this concept has remained a fixture in the lien law, this idea that in order to claim a lien, you have to add economic value. And I've seen, I don't mean to be derogatory relative to architects, and I know sometimes it sounds like I am, so please overlook that. But I've seen these definitions of architecture where it is, probably the best one I've heard is, it is the manipulation of time, light, space, and matter to create an aesthetic. And that may be a good definition. That may actually be a good definition, but the problem is, when you say that to a judge, they look back at you cross-eyed, like, what am I supposed to do with that? How am I going to extract anything objective from that definition to make an intelligent determination as to whether or not you've improved the value of the real estate? That's the question in front of me. To be fair, judges cross their eyes over much simpler things than that, but be that as it may. Some days you wonder, Judge, you just want to, Judge, I don't want to be rude, but I have a basic question, Your Honor. Did you ever go to law school? Can't obviously do that, but there are days when you want to. Be that as it may, the existing process. So, We can claim a lien. How do we go about doing it? Anybody who has provided labor or materials for a construction project, including the design professional, but hasn't been paid, may claim a lien by simply recording the claim of lien in the chain of title. And that applies to everybody. Construction contractors right down to individual laborers. The guy driving the screws in the drywall, if he isn't paid or she isn't paid, or the benefits aren't paid into their union fund, they can claim a lien, and they do. You see that sort of thing happen all the time. So it's a pretty broad right, and literally all it takes is improving a real estate, working on a construction project and not being paid for the materials or the labor that you provided. There's a couple of limitations. I say the claim of lien has to be recorded in the chain of title. It has to be recorded within the chain of title within 90 days of the date of your last work. And there's a reason for that. One of the questions that came up in the context of the bill we're about to talk about was, well, let's extend that to a year. Well, that's really not going to work, guys. In fact, if we look at other states, what we see is that 90 days is already very generous. Many states have a 30-day window. And what I get from architects and engineers is, well, 90 days is not overdue in our profession. Well, that may be, but 90 days is about as far as you're going to go, and there's a reason for that. The idea is, if you have a claim, make it. If you're going to make a claim, then do it. We don't want these liens tying up the title to real estate for months and months and years. So that's why it's relatively short. It's sort of a balancing act. If you're going to make the claim, we want you to be able to make the claim. But we're not going to let you tie up the title to the real estate for the next 5 or 10 or 15 years. We want the title to the real estate to be free and clear so it can be sold, transferred, so that economic activity relative to the real estate can continue to grow and be engendered. And quite often, design professionals, in my experience, more so architects, think that because they've claimed a lien, they're going to get paid. And that's well, maybe you've taken a step in that direction, but you still have to file a lawsuit. You have to file a lawsuit to foreclose that lien, and you have to file the lawsuit within 1 year of the date the lien was claimed. Now, there are ways, maybe I shouldn't share some of this, there are ways to manipulate that 90-day window. I get calls occasionally from architects, well, I haven't been paid. Well, when did you last work on the project? Well, about 5-6 months ago. Well, might be too late to claim a lien. So the question then becomes, are you under contract to do any more work that you haven't done? Well, yeah, I still got some shop drawings I could review. I didn't do it because I wasn't getting paid. Pull those shop drawings out of your file cabinet, review them, send them back to the owner, and then call me back after you've done it. Now, why am I doing that? When those shop drawings are reviewed, we now have a new 90-day window, as long as it's basic work that you're under contract to do. So you can manipulate it a little bit if you're a little bit creative. In the end, it really becomes a breach of contract lawsuit. The claim and the lien have to be the claim. By claim, I mean the underlying debt. The fact that I am owed money that I haven't been paid, that has to be valid. You have to prove that. And you also have to prove that your lien claim was made in the right amount of time and all of these other sorts of things. And if that all happens, in theory, what a lien claim ultimately leads to is the seizure of the property. The property would be auctioned, and the proceeds are used to pay the lien claimants and the mortgage and all of these other sorts of things. In reality, that never happens. In 32 years, I've never seen that happen one time. And the reason for that is it's not like a question of, well, do you believe me or don't you believe me, like many lawsuits turn on. And then it's a question of putting your witnesses up and asking them questions, and who does the jury believe? Well, in this case, everybody knows what's going to happen because the dates are a matter of record. The contract is a matter of record. You did the work, you didn't get paid. There's really nothing you have to prove. You can sit down and look at it and come to the conclusion that that's a valid claim. So once everybody does that, we all know what's going to happen. So there's no point in litigating. So instead, we work something out. These lien claims always get worked out in some fashion. Cases get started, they never get finished. And that's literally the reason. There's no point in litigating if we know what the end result is going to be. So this becomes the difficulty. We're getting to the point where now the design professional has a problem that the construction contractor doesn't. You have to add value to the real estate. There has to be some improvement. Without improvement, there is no lien right. And the odd thing becomes any amount of improvement is adequate. So if you're owed a $30,000 fee, it doesn't matter that the actual physical improvement may have improved the property by $10. So there is no requirement that the two are related in any way. There must be the actual physical improvement to some extent. And how this became an issue is, or why it became an issue, is that literally we don't know in many cases, is there actual physical improvement? So lenders would send somebody to the construction site and review it before they extended a loan. Literally, go out there and tell me, has there been any construction? Which is a shorthand way of saying, has there been any actual physical improvement? And you'll see why that's an issue here in just a minute for the lender. And they would send people out in the field to make that determination. And unfortunately, it's something of a subjective determination. Because how do we resolve whether or not there's actual physical improvement? We do it my favorite way. We litigate it. And you have cases coming out all over the place. You had some judges saying, because the contractor put a bulldozer on the site and did some clearing, that's actual physical improvement. And you have another judge with a very similar case saying, no, that's not enough. That's not actual physical improvement. So it's all over the map. You have hundreds of these cases. And it even gets worse when you start looking at renovation projects, because now you have the developer sending his teenage son and a couple of their friends out there on a Saturday, and they start taking down some of the acoustic ceiling and throwing it in the dumpster. Well, is that actual physical improvement? Some judges said it was. Other judges said it wasn't. So you can imagine what it would be like to be the guy that gets sent out in the field by the bank to determine whether or not there's actual physical improvement. I can tell you what's going on, but I can't draw the conclusion necessary to tell you whether a judge is going to say that's actual physical improvement or not. And that becomes a sticky issue, not just for the design professional, really across the board. It became a problem for the design professional that the statute was modified to fix. And the reason that this physical improvement becomes the critical date, without the lien, or without the physical improvement, there are no lien rights, but it also becomes the day on which the lien physically attaches to the property. When I claim the lien, I'm just putting in the chain of title an indication that I might have a claim. In order for that claim to be enforceable, it actually has to attach to the title to the real estate. And the date on which there is actual physical improvement becomes the date on which all of the liens claimed under the lien statute attach to the real estate. And there's a reason for that. The lien statute is like the bankruptcy statute. We look at real estate, and sort of the general rule is whoever makes the first claim has the superior claim. And what you'll hear title insurance companies or lawyers saying is first in time, first in right. In other words, whoever made the claim first has the first claim, and then you work downwards. Well, the idea was, with the lien statute, that anybody who made a claim under the lien statute would have the same date of priority. So we don't want this race. So now you have a foundation contractor that's claimed a lien, and they did their work last week, and then you have a painting contractor that doesn't do any work until 2 years from now. They all have the same priority. So the theory is, if we get to the point where we auction the real estate, we sell it, painting contractor, you have a claim that's 9% of the total claim, so you'll get 9% of whatever the proceeds are. Works just like a bankruptcy. And that's why everything attaches at the same time. That's also why banks are concerned about it. That's what we just said. To afford all lien claimants the equal opportunity, they all attach at the same time. That's also why banks are concerned about it, because we get some construction going, say we put the bulldozer out there and we clear some trees on April 1st, bank comes along, extends a loan on April 15th. And now 2 years down the road, you have a painting contractor who hasn't even yet been hired claiming a lien. Well, the effective date, the attachment date, the priority date for their lien is April 1. That's earlier than the bank. So now the bank is in a position where, wow, people we didn't even know were going to be here have a claim that's ahead of us. And banks don't like that. Banks like to be first. That's generally what they're trying to do. So why is that a problem for the design professional? Or why was it a problem for the design professional? What is the first thing the bank wants to know when a project is started? Well, what do you want to build? Well, I need $2 million. That's great. What are you going to do with it? So you need to be able to show the lender the nature and extent of the project. And that means you need a design professional. You need probably a civil engineer. You almost certainly need an architect. So you have something to show to the bank. The problem becomes, what if there's no construction? What if there is no actual first date of physical improvement? You can still go to the registrar of deeds and fill out the lien claim and record it. But if that lien doesn't attach to the real estate, so what? It's not enforceable. It's worthless. And that was literally the problem that design professionals faced. So we get into changing the law. And the one thing you learn very quickly about legislation is it's a mess. And it starts out as a mess, and then it gets worse. There are just an unlimited number, it seems, of groups, all of whom have an opinion and all of whom have an idea about what you should be doing. And you have to address each of those groups. In many instances, you're never going to get them on your side. I don't expect you to support what I'm doing. What I want you to do is agree not to oppose what I'm doing. And that can be key, because if you have larger groups that don't actively oppose you, the fact that they're sitting on the sidelines really makes something possible that otherwise wouldn't be. And if we look in the context of design and construction, I worked with a couple of the local professional societies for close to 30 years on a number of different legislative issues. And to give you some examples, we had an unfortunate Supreme Court decision a few years ago that extended the Michigan statute of limitations for design professionals from 2 to 6 years. And it happened because we had some judges that acted like they'd never been to law school. But be that as it may, the effort then became make it 2 years again. Well, if you understand the legislative process, the House is elected every 2 years, Senate in multiples of 2 years. But at the beginning of a 2-year cycle, we just started one here in January, you have 2 years. If you introduce a bill any time in that 2-year period, it has to be signed into law before the end of the period. If it's not, it's dumped and you start over again with the next 2-year cycle. The statute of limitations took 7 years, 4 tries. And the first 3 times, it was bottled up for political reasons, which gets incredibly frustrating. But that's kind of how it works. And if you look at why do we have a 2-year statute of limitations for design professionals in Michigan, I think it's because Rick Snyder was elected governor. And whatever you might think of Rick Snyder, when he came into office, his mentality was pretty well known. And we had run into trial lawyers year after year after year, and I don't think they even cared about what we were trying to do anymore. I think they just wanted to use it as a trade-off. And when Governor Snyder was sworn in, we reintroduced the legislation in January, and by May it was the law. The trial lawyers didn't even bother to show up because they knew it wouldn't do any good. So that becomes a dynamic, and the reason it's an issue here is because there are some pretty large construction groups out there. If you look like at AGC, they're very well financed, they're very well funded, they're not particularly effective, but they're big, and they can, for lack of a better term, throw around their political girth, and they do it. So keeping groups like that on the sideline was very important. And it was an issue here because the law does apply to them. The lien law also applies to construction contractors. And the upshot of that is that legislation often doesn't produce, in fact, never produces the ideal. It produces, hopefully, something that solves a problem that becomes possible and not really what you want to do. So, what became the underlying concept? What did we do and what change did we make? Well, the idea was to allow the design professional lien to attach even though there's no physical improvement. We had to do that without altering the rest of the lien law, because the rest of the lien law applied to construction contractors, and as we just said, we want them on the sideline. So we can't change anything that applies to them. Preserving the current structure for projects where construction occurs was critical, because we didn't want the opposition from all of these groups who would begin to argue that we're changing their rights or affecting their rights as well. So how do we implement that? Well, when there's no physical improvement, then obviously something else has to create the date on which the lien attaches, right? We're not using physical improvement anymore for design professionals because we don't always have physical improvement. What my initial thought is let's just write a true design professional lien. Let's do what we ought to do and recognize that design services create value. Well, that was just completely impossible. That was never going to fly. So that idea was cast aside pretty quickly. There actually is one state, in Massachusetts, they do have that kind of a statute. It would never have happened here, so we got to set that aside. We did borrow from the Massachusetts statute, however, and the idea becomes adding a filing. We're not using the first date of construction or the actual physical improvement anymore. So we're going to file something in the chain of title that stands in for that creates what the actual date of first physical improvement would create relative to the design professional. And here comes the opposition out of the woodwork. The first group we ran into was land title insurers. And they are these people that write those title insurance policies that you see every time you buy real estate. 100 years ago, 50 years ago, for that matter, even 30 years ago, what you did when you bought a piece of real estate was a title search, which turned up all of these, every deed, every claim that had ever been recorded for that piece of land. And then you took it to a title attorney and got an opinion about whether or not you had good title. And you could still do that today. The only problem is you can't find title attorneys anymore because they just don't exist. So what we do instead, we still do that title search, but now we insure it over. We buy a title insurance policy. So here's the titles. Here are all of the recorded claims. And if anything creates an issue, creates a problem or a cloud on your title, you got an insurance policy to cover it. The title insurance people were concerned about a couple of things, and some of it's legitimate. I think some of it's just manufactured. They were concerned that design professional liens would be deemed superior to loans after the loan was advanced, because when the loan's advanced, they guarantee title. And after I've guaranteed title, now there's a lien. Well, that was kind of a manufactured concern because that's the case now. So it's like, okay, guys, I hear you talking, but I don't hear what you're saying. It doesn't make a whole lot of sense. And not to be derogatory relative to lawyers, but in some instances, I think different groups have lawyers that are expected, or they think they're expected, to offer some sort of commentary. Whether it's legitimate commentary or not, that's another question. I have a client, the client wants to know what I think of this proposed change to the law. I got to say something. I can't just say, well, I don't see an issue with it. So I got to tell them something. Well, and there's two reasons for that. Because they expect me to tell them something, and also because if I write a memo, what do I get to do as a lawyer? Send them a bill, and that's very important. Actually, that's only a step to the most important thing. Having them pay the bill is the most important thing, but you can't collect it until you build it. So there's some of that going on. That concern about guaranteeing title after or having a lien crop up after you've guaranteed title really was not, I didn't think, a legitimate concern. And in fact, what we were proposing would have made that better for them anyway, right? Because they're going to go to the chain of title and search it anyway. And if the design professional has recorded a notice in the chain of title, they're going to see it. So instead of having something jump up and bite you, where all of a sudden a judge is saying, well, the contractor cut down a tree and that's actual physical improvement, there's not going to be a design professional lien unless you actually see that recorded document in the chain of title. So this is actually better for you guys. Well, they kind of accepted that, kind of didn't. But then the next question, and this actually probably was legitimate. They say, if this notice is recorded, how long is it good for? Can somebody make a lien claim 19 years in the future? Well, yeah, I suppose they could. So in order to address that, it was not something they wanted to ensure open-ended. Satisfy them. Then of course we get BOMA, and I'm not honestly certain what their complaint was. I just know it manifested in the form of an 18-page memo from their lawyer. Much of it was, well, you can't really have a lien if you don't have first physical improvement. Well, yeah, under the current law. But that's what we're trying to change, right? So I don't understand why you're spending 16 of your 18 pages explaining that to your client, unless I write it off as 16 hours at $400 an hour, which I kind of do. So they had a huge pile of opposition. and none of it really added up to much or went anywhere. Their real concern, when we stripped it all away, was the extent to which a owner could be subject to a lien claim without the owner's consent. And that's kind of addressed in the current statute. I don't know if that's a legitimate concern, but that's at least something we can work with. We can address that. And we did that by folding the current case law into the statute, which we'll talk about in just a bit. And then we have the lenders. And their concern was really simple. They just wanted to know how to determine whether there are potential lien claims before they advance loans. And they're obviously a pretty large and well-heeled group, so if they mounted opposition, it would have been done and over. Nobody's going to do anything that banks don't want to do. They have that much political power. However, this argument that we made with the land title insurers really resonated with them. It's like, you don't have to send anybody out to make this determination anymore. All you got to do is check the chain of title, and you're going to do that anyway. So look and see if the notice is recorded. They actually liked that, and that was about all we heard from the lenders. They really bought into that idea and said, well, doesn't that actually make it better for us? Well, I think it does. You got to ask your own people whether they think it does. And in the end, that was about all we heard from them. This group was also, as we've said, a little bit scary in terms of what they could have done had they mounted some opposition. And in the end, they didn't do anything. Nobody really came along, so we were quite surprised about that, actually. They threatened a lot, but they didn't actually get involved. So, what do we have to do? We have to write a bill that allows the design professional's lien to attach in the absence of physical improvement. We have to address all of the concerns, legitimate or manufactured, and we have to preserve the status quo otherwise, because if we don't, then we have opposition. So that sort of becomes the challenge. So the response is, in order to claim a lien, the design professional has to first record a notice of design service contract in the chain of title. And if you've ever recorded a claim of lien, there's actually a form in the statute. There's actually a form for this right in the statute. You can look it up and pull it right out. Now that recording affords notice that there are potential design lien claims out there. Any lender or any title insurance company checking the chain of title will know that before they extend the loan, which is really all they want. It isn't a situation where we're not going to give you a loan if there are liens. We just want to know what's out there so that we can make an intelligent decision about what we have to do. Although the notice can be recorded at any time, it has to be recorded before you claim the lien, but it can be recorded at any time. It does not have to be recorded when you start the work. The only thing that can happen if you don't is a lender can come in and extend a loan. And let's say, go back to my example. You start the work on April 1st and you record the notice of design professional service contract on April 1st. Bank extends the loan on April 15th. Now your lien claim is superior to the bank. You start the work on April 1, the bank extends the loan on April 15, you record the notice on April 30. You still have a valid lien claim, but you're behind the bank. You're in line after the bank. So if we get back to the situation where the property is taken and sold at auction, the bank is going to get paid first before you get paid. So that's really the only effect of that. And there are some limits on the notice. As we said, it expires 1 year after it was recorded in the chain of title. You can record another one if you have work that's incomplete after a year. You can record another notice. Each one is also good for a subsequent year. And that limit was really there to address land title insurance concerns. This is a bit of a change. There has to be a written contract in order to have a lien claim. The lenders had what they said, I'm not sure it was legitimate or not, but they said they had a concern over bogus lien claims. Well, under the current law, you can claim a lien if you're not paid. You're not required to have a written contract. You have to have a contract, not required to have a written contract. And actually, when this came up, when that demand came up, I was working with ACEC at the time, not with AIA like I had for a bunch of years. And I immediately asked ACEC, what do you guys think about this? And they say, well, we don't have a problem with it. You know, ACEC, their membership is firms, and they tend to be large firms, not architects. Architects are either huge firms or small firms. There's nothing in the middle. And architects are far more likely to not have the written contract. So at the time I was working for ACEC. ACEC said, if this will make this go, we're good with it. We don't have a problem. And I talked to the AIA Government Affairs chair and pointed out that this was in play, and if they had something to say about it, they should do it. They didn't say anything. So we went forward. Now a written contract is a requirement. Written contracts obviously are always a good idea. And if you do continuing ed, your insurance people and anybody that'll tell you is hammering on you, get a written contract, get a written contract, get a written contract. And there's a lot of value in that advice because, you know, you have a contract, even if you don't have a writing, you have a dispute over what the terms are. Everybody thinks they're different. An oral contract is every bit as enforceable as a written one. The only problem is you don't know what you've agreed to. What I think I've agreed to and what you think you've agreed to and what you think you've agreed are all different. They may be all the same at the time we enter into the transaction, but when we have a dispute, they're all different. So we have that issue. And I get questions about, well, what does that mean? Would a letter of intent be at no written contract? I mean, we all know what they are. And then the question is, well, what if somebody, we're negotiating a contract and we hand around a draft and it never gets signed? Well, under the law, that could be a contract. Basically, what you've done is manifested your agreement by your conduct instead of by your signature. The problem is that what stands between you and having that deemed a written contract is a chunk of litigation. Not that that would bother me any, but from the architect or the engineer's perspective, yeah, maybe that draft you exchanged will be termed a written contract. That could happen. There is legal precedent that suggests that's the case. The problem is what stands between you and that is this cost. And of course the risk that that's not going to be deemed to be the case. So it is a written contract. We know what they are. I kind of use the term, I answer when I get the question, well guys, it's not rocket surgery. And that's not a misnomer. That is the most difficult concepts associated with rocket science and the most difficult concepts associated with brain surgery blended. It ain't rocket surgery. We know what a written contract is. We all do. And I'm sorry, I don't want to get off on a whole nother argument, but it's kind of a pet peeve with me. It's like, and again, I don't want to sound derogatory towards architects. Engineers tend to be far more pragmatic. They're much more business-like. We got a problem. All right, how do we solve it? What are we going to do? And you set the architect down, and we got a problem. And the next thing you know, they're up on the barn threatening to jump off. They're just a whole different thing. And It is what it is. We all know what a written contract is, so get one. Your insurance carrier will tell you to do it. You have to have it to claim a lien. Now, you don't have to have it to make a claim. If you have a deal with a client and you're not being paid, you can sue that client for breach of contract. You just can't claim a lien if you don't have a writing. So what do we do to claim the lien? Well, process stays exactly the same, and that was one of the overriding goals. That's what we're trying to achieve. If you aren't paid, you record your claim of lien within 90 days of your last day to work, just like you always did. And a lawsuit to foreclose the lien has to be filed within 1 year of the date of the claim of lien, the date of the recording. Just that, nothing changed. That's the same. Now, this is where it diverges. Is there physical improvement? If the answer is yes, there is physical improvement, nothing changes. It stays exactly the same. This is always going to be the case for the construction contractor, right? We never have a situation on the construction side where we have a lien claim, but we don't have actual physical improvement. And you say, well, what about ordering materials? Well, it's very well settled. The case law says if you order materials, that's physical improvement, as long as you can show that those materials are traceable to this project. It's not like, I sell drywall and I ordered 5 truckloads of it, and, I'd have sold some of that to you. Well, no, that drywall is not traceable to this project. That's just general commodity. So this was never a problem for design or construction contractors. All liens, including the construction liens, attach on the date of actual first physical improvement. Remember, this is where we have it. If we have actual first physical improvement, that's when the liens attach. All liens have equal priority. Everything claimed under the Construction Lien Act attaches on that single day. Again, none of that's really a change, but this is where we have a change, where we don't have actual physical improvement. The lien still attaches. You've claimed it exactly the same way, and for purposes of attachment and priority, the date becomes the date on which you've recorded the notice of design service contract. So we solved the problem. We've made the lien that the design professional has claimed, where there is no actual first physical improvement, nevertheless attach to the real estate. So that literally solves the problem that we set out to solve. We made a couple of trade-offs to get there, but that gets us to where we want to get. Now the question becomes, to what extent does the lien attach to the owner's interest? If you use the legal term, it's the fee. You got to throw the Latin in there every once in a while so people know you went to school. The owner doesn't own the property. The owner owns the fee. I have no idea what that term means or where it comes from. So the question is, does the design professional's lien attach to the ownership of the real estate? And the existing law addresses this, and it's not something that we changed. Under the existing law, the lien claim attaches to the interest that the person with whom you're doing business holds. And you say, well, what does that mean? Well, what that means is, let's take an example. Let's say you have a client that's a tenant. You've got an owner, owns the building. You've got a client that doesn't own the building, but has a lease with the owner. Your client is the tenant. So what interest does your client have? Your client has a lease. That lease gives them the right to occupy the real estate. If you claim a lien in that context under the existing law, under the pre-existing law, the lien would attach to the lease, not to the owner's interest, not to the fee, because that's all that the person you're working for has. You can't attach something they don't own. And that was the law prior to any of the changes. However, there are circumstances where the lien may attach to the owner's interest. And that becomes a question of whether the person for whom you're working is an agent of the owner. If that person is an agent of the owner, then your lien may attach to the owner's interest, which obviously you want it to. And that's a question of the degree to which the owner controls the business relationship between the tenant and the design professional. This actually came up. This was, I said earlier, the owners were concerned about being exposed to lien claims they didn't consent to, and we were arguing over it. And to cut the argument short, the response was, well, under the existing law, you use these case terms. There's been a case and it's got a name, and you use that name to sort of describe the principle. In Michigan, we have this case that everybody refers to as Norcross. It's Norcross versus somebody. And that's what the court said, is that if the owner, if the tenant acts as an agent of the owner, then the lien will attach to the owner's interest. So to cut the argument off, the response became, well, you agree Norcross is the law, right? Well, of course. All right, let's write it into the statute. And that ended the debate. I don't really think that's what the owners were debating with us about, but it did end the question. And you see that more often than you might expect. If you look like at a Taubman lease, they come with like a pickup truck full of paper. There's a bunch of books, our mall design standards and our space fit-up standards and our standards that apply to our standards and all of this other stuff. And if you read the lease, the tenant is required to comply with all of that stuff. And that's been litigated a number of times. And the courts say, well, with that degree of control, Taubman, that tenant is your agent. And the Taubman, they're not stupid. They know that. They're just willing to accept it. Okay, we'll live with it, because it gets us what we want in that building. So it becomes a question of degree, and that was something that got litigated anyway, so that didn't change either. The only change was that the case was actually written into the statute. So instead of having something sit out there that some judge decided, it's now actually legislation. That may be a point that could be addressed again in the future. That's kind of something that still would require some litigation. But as I said, legislation is incremental. And if you try to take too big of a step, you don't go anywhere. Now, question becomes, how do we deal with sub-consultants? Because they may have lien rights as well, or they typically did have. It changes a little bit, but not that much. The process is exactly the same for a sub-consultant. You have to file a notice of design service contract if you are a sub-consultant in order to perfect your lien rights. The only rub becomes that, and this again was an owner thing, the sub-consultant must be approved, it should say by the owner right there. And so then the question becomes, what does that mean, approved by the owner? Well, it's an easy answer. I mean, you don't literally have to take the sub-consultant into the owner's office and say, here's my structural engineer, do you approve? You can write it in your contract, and remember now you are going to have a written contract. I am using ABC structural engineers, I am using XYZ mechanical, electrical, and plumbing, and the owner approves their engagement. Just write it right into your contract. So it's not a big deal. You can get over that approval. There's probably a lot of ways to do it, but that's the easiest way to do it. Just put it right in your contract. Now, one of the sort of responses that I get typically from insurance carriers and design professionals is, this is all great. What kind of clause do I write in my contract? It's created by the statute. There is no contract response. You don't put anything in your contract. You don't have to put anything in your contract. You might put language approving your subconsultants like we just talked about, but relative to your lien rights, they exist as a matter of law independent of your contract. They have nothing to do with your contract. Completely nothing to do. Now, I get this question a number of times from insurance carriers, some of them that I do a little bit of work for. They say, well, you know, one of our insureds has got this clause that an owner is attempting to force on them. They have to waive their lien rights. Well, that's fine, but it's not legal. There is Michigan law on that question. A person shall not require as a part of any contract for an improvement that the right to a construction lien be waived in advance of the work performed. So you have these clauses that owners want you to put in your contract. Guess what? They're not enforceable. So I'm not saying ignore them. I think you still should try to negotiate them out. I think you should point that out to the owner. Michigan Compiled Laws Section 570.1115 subpart 1 says you can't do that. You can go ahead and put it in the contract if you want. It's just not going to be of any effect. So when I claim my lien and you say, oh, but you're breaching the contract, my response is that clause is not valid. So it's kind of a non-issue. But this always seems to be the question is that, well, what do we do in a contract? Well, contract is only a small part of what you deal with. And many times there's nothing. So in this case, there's nothing. There's no contract clause required. There's no response required. So in the end, what do we have? We have a design professional lien that attaches without physical improvement. We have a process which is clarified. We're not dealing with actual physical improvement anymore. We're not litigating that question. Well, I say we're not. The owner may be litigating it with the construction contractor, but that's between the owner and the construction contractor. It doesn't affect the design professional. Go litigate with them all you want. Our date is the date we recorded our notice. That's all we got to do. So we've certainly, it's probably not correct to say the lien process is clarified. It probably should say as with respect to design professionals, because that's really the only place the change was actually made. So, you know, a couple of things. You got to record these notices to perfect your lien rights, and you do have to have a written contract. And frankly, if we had seen that immediate effect vote coming, there might have been some thought given to how to transition into it, but we didn't see that coming. And the next thing you know, it's on the governor's desk and it's signed and it's effective. So it could be an interesting question. What happens to projects where the project was initiated prior to these requirements? Project was started last October. Well, at the time the project was started, there was no requirement to record anything like this. My intuition says if that were ever to be litigated, the court would say, well, we'll just follow the old law up until the date the new law became effective. I certainly have no way of guaranteeing that. Lots of crazy things can happen. But that's my thinking as to what would happen. And like I say, we would have thought that through and added some language that says that's what's going to happen if we had seen coming what came. So in kind of a big nutshell, that's the change. And it is different. The process is different now. There are things you have to do you didn't used to have to do. You have to have these recorded notices. You have to have written contracts. You know, I'm not sure. I believe the process is an improved process. The whole written contract thing, you know how it happened. Whether it was the right thing or not, I guess I don't know. But anyway, that's what it is. So we're at the end, and I said there'd be an email address. It's right there. If you want a copy of the PowerPoint, send me an email and I will send it to you. You can use it for notes and reference. I just ask that you not reproduce it and use it for presentations or anything like that, not that you would. So that's basically that. We have changed the law, I believe, in a manner that's for the better. And I'm really surprised it happened as quickly as it did. It was 8 months and everything just seemed to line up, which surprised me. It's like, this never happens like this. I mean, we had issues and right away we were able to resolve the issues and move on, and the concerns we had over opposition we were able to deal with, and it never came along, and in the end, that's the law now. So thank you. I need to get close to you so I can hear you. Okay. Not your problem, it's mine. I have a good hearing aid, and it's really rough getting to the point where things don't work anymore, but I go to the audiologist to get my hearing aid repaired. Well, why am I getting my hearing aid repaired? This is great, you'll love it. You won't even know you're wearing it. And I didn't, and I got in the shower with it. Now it's being, electronics and water do not play well together. So I have this thing I'm struggling with, and then she gives me this card that says hearing aid. Well, what am I supposed to do with that? Clip it on your shower curtain. Oh. So anyway, I'm sorry.
No problem. So with the notice of design contract, is there any notice sent out to the owner that you actually filed that?
Yeah, the question is there when you record the notice of design service contract, you treat it the same as you would any other document that's filed under the lien statute. And it is not simply recorded in the chain of title. It is recorded in the chain of title, but copies of it are also sent to the owner's representative. Yeah, and in fact, the owner can designate. If you've seen like a notice of commencement, that's what the owner is doing on the construction side, is saying, this is my designee, this is the person that's handling this for me, send them all the notices. Well, you won't see that here, but you will send a notice to the owner as well. You record it. Once you get the recorded copy with all those fancy stamps on the top of it, you'll send a copy of that to the owner. So they'll know it's there. And once it's in the chain of title, lenders know it's there as well, because it's kind of the rub. It's like, well, you guys want to make arguments that don't make any sense. You want to make these arguments and act as if you don't know what's in the chain of title. I know you check the chain. Everybody does. And come on, it costs $300. You went to the title company. You're not going to make $1 million or a $5 million loan without spending $300 to do a title search. I know you did it. So what's the issue? Well, we don't know about the... No, you do know. So anyway, that's why I say some of this stuff is probably manufactured argument and not so much. I think a lot of times when you deal with legislative questions, it isn't so much that anybody opposes it. It opposes what you're trying to do. They just want to oppose. And if you're opposed long enough, the truth comes out. I talked about the statute of limitations and the trial lawyers, and that came right down to the end of the session all 3 times it died. And, they're opposing, but they never really had a principled opposition. So then when the question became, well, why are you opposing? It sort of little by little leaked out that what they wanted, it wasn't that they opposed what we wanted to do. They were trying to get the other side to trade something. We want this, you want that. We'll drop our opposition if you drop your opposition. It had nothing to do with whether the bill was the right thing. They didn't even read it. They didn't even know what it said. They're just trying to make a deal, to trade their opposition for something else. I mean, that's not the way it's supposed to work, but that is the way it works. Again, I'm very surprised that we were able to do this as quickly and neatly as we did. It's like, wow. Anyway, I think it's an improvement. I think it solves a problem that some design professionals suffered with. And, you know, there are some trade-offs. You got to have the written contracts, and there's a little bit of legwork you got to do. You got to record that notice, but that's not a big deal. You know, it's $9 or whatever it costs to record the notice, and you just do it. If you know, I'm not suggesting, you know, if you're doing a dining room renovation for grandma on the corner, you're probably not going to record a notice of design professional contract, so you're not worried about it. But it's like with everything, there is a degree of business judgment that goes into it. Is this a project they might have a problem on? Is this a project the dollar value is significant enough where I need to protect myself for the cost of $9 or $13? Yeah, so, you know, it's a judgment thing, as most things are. So, thank you.